And you are live, Allison.
Great, thanks, Beth. Good morning, everybody. And for those of you who don't know me, my name is Allison McGee, and I am one of the sales and leasing managers in the Westlake and Lake Travis offices. So I see a few familiar faces, but a lot that are probably from the other offices. So welcome. What we're going to go over today is deep dive into the lease agreement document and some of the related addendums. And we like to go and do this once in a while because the lease agreement is a really complex document. So it's quite a bit longer than even the 1-to-4 contract. And people often wonder why. You'd think purchasing a property would be a bigger deal than leasing your property to a tenant. But if you think about it, the purchase contract is, maybe 30 to 45 days long, is that relationship between the buyer and seller. And once the closing occurs, that relationship is ended. But with a lease document, the relationship between the landlord and the tenant can be 12 months or 24 months, even longer. And the landlord is allowing somebody to live in the property that they own. And given the value of real estate, to let somebody else use your very, very expensive investment, you need to be really, really clear what the obligations and the responsibilities are for both parties. So that's why it's such a long and complex contract document. And it's really important for you as a full service real estate agent to understand it, whether you're representing the landlord or you're representing the tenant. So with the landlord, you need to be able to explain to your landlord what their responsibilities and rights are, so that you can help them decide on the best terms and help them understand how they need to interact with their tenant. And then if you're representing tenants, it's very important for you to understand the document so that you can explain to your tenant client what obligations, responsibilities, and rights they have. So I'm going to go ahead and present my screen. And as you guys probably know, I am not going to be able to see you or to see the chat function while I'm presenting. So we'll take a break maybe in about 45 minutes or so. And if people want to put the questions in the chat, or you're welcome to just unmute yourself and interrupt me if there's something specific that you aren't understanding that I'm presenting. So I'm going to do this as a slideshow. Okay. So we use the Texas Realtors residential lease form. And of course, like with any contract, it starts out with naming who the parties to the contract are. So the parties to the contract are the landlord, and then the tenants are whoever are the adults living in the home that are signing the lease. So sometimes there can be other occupants in the home that are over 18, but they are not responsible for the lease. So for example, if you had a family and it was a mother and father and their 20-year-old child, the 20-year-old child may not be signing the lease. They're not going to be responsible for the payment of the lease and for the other obligations, but they are an occupant. And there is a place in the lease where you list occupants. And then, of course, you have to specify what the property is subject to this lease. So the address, the legal description. And then this is also where you would enter any non-realty items. So if the landlord is providing a washer and dryer or a refrigerator or anything else that does not fall under the definition of real property, you would enter this here. That doesn't mean, like with the 1-to-4, it's not the stove, it's not the dishwasher that's installed, it's things that are not attached to the property. So one paragraph, and I'm not going to go through every single paragraph. I'm going to sort of skip to the ones that are important. Paragraph 4 says that the lease will automatically renew on a month-to-month basis unless the landlord or the tenant provides written notice of termination. And this is the paragraph where you specify how much notice the landlord or the tenant needs to provide after, and this doesn't mean that this notice is automatically termination, but when you're getting to the end of the contract, or if it's gone to a month-to-month, this is the amount, the number of days notice that each party would need to give the other for terminating the contract. And you can check either A1 or A2. A1 defaults to 30 days before the expiration date. But I like to put 45 days. And the reason for that is it just gives the landlord a little bit more time to prepare the property, to execute a listing agreement with you so you can help them lease again, things like that. So it's just a little bit more leeway for the landlord. And it's not out of the realm of reasonable in our market. If you look at apartment complexes, most apartment complexes actually require 60 days notice. And that paragraph continues, and it says, if the lease automatically renews on a month-to-month basis, it will continue to do so until each party is providing written notice. And then I usually like to check box 4B1, and that says that the notice of termination is effective the last day of the month after the notice is given. So, if it's 45 days notice is required, then it would be 45 days and then to the end of the month. And again, that's just going to give your landlord a little bit more time to get the property leased out so that there's less chance of a vacancy. And then paragraph 5 specifies what the monthly rent is and when that rent is due. So you can either have it due upon the signing of the lease or at the move-in date. I like to do it at the signing of the lease so that, along with the security deposit being provided, then the landlord has that first month's rent so that if something were to happen and the tenant didn't end up moving in and was in default, the landlord will at least have been paid that first month's rent, which would be equal to your commission. So we recommend that you have the first full month's rent paid by cashier's check or money order made out to JBGoodwin Realtors. That way, the landlord that commission is automatically getting paid to you when the lease is signed, because you have done your obligation with the lease listing agreement. And then we don't have to invoice the landlord. It just makes it a little bit easier. And then typically the rent is going to be due the first day of each month after that. And of course, there can be negotiations where, if a tenant isn't paid on the first of the month or something, that a landlord might be willing to accept rent on another other than the first day of the month, in which case you would check box 2 and specify when that's due. Now, if a tenant is not moving in or the lease agreement is not starting on the first day of the month, then you would need to use paragraph 5B, and that's the prorated rent. So what we usually do is have the first full month's rent paid upon signing, and then you would do the prorated amount if they were not moving in on the first of the month, paid on the first day of the first full month. And you would then calculate whatever it is the day that the lease begins to the end of the month, and they would pay that much or that amount on the first day of the first full month. So you're essentially switching that first full month's rent and the prorated rent for that first partial month, if that makes any sense. It can be a little bit confusing to folks, but again, it's really to make it easier for the landlord to meet their obligation to pay your commission and it doesn't require our accounting department then to have to invoice the landlord. And paragraph 5 continues and specifies how the tenant will have to pay rent after paying that first full month's rent. And we're seeing more and more that landlords are only allowing for electronic payment. That way they're not having to deal with mail delays or things like that. And it's just a much easier way to accept payment. But of course, that is negotiable. Typically, we do not have landlords charging anything to accept any particular type of payment. And always recommend there on 5D4 that the landlord require that the tenants pay the monthly rent by one payment. This is particularly important if it's being rented to roommates, so that the landlord isn't having to, chase after one tenant that, didn't pay their 1/4 of the rent. Just require the tenants to be the ones to collect the rent and make one payment to the landlord. So if the tenants are not paying the rent on time, paragraph 6 deals with late charges. And this is where the landlord would specify at what day of the month rent would be considered late. And we usually see that it's the third day of the month. And then the landlord can charge a late fee, an initial late fee for the first day that it's late, and then additional fees for each additional day. Now, a couple of years ago, the state legislature passed Senate Bill 1414, and that limits what landlords can collect from tenants for late fees. And it limits it to an amount not more than 12% total. So the late fees in total cannot equal more than 12% of the monthly rent, unless the landlord can show that there are direct costs associated with the collection of that late payment. So, that's just something to point out to your landlords, because it doesn't take that long to reach that 12%. I usually put a late fee of, $50 or $100 for the initial charge, and then, $25 or $50 a day thereafter. You want to make sure that it's enough to really dissuade late payments. But again, understanding that at some point those, daily charges are going to reach that maximum of 12% for that month. Did somebody have a question, or was somebody joining? Okay, must not have been a question. And paragraph 8 is really important, particularly for your tenants to understand. So this says that regardless of any notation on a payment, that a landlord can apply the funds that they receive from a tenant first to any non-rent obligations, including late charges, return payment charges, repairs, things like that. So, for example, if a tenant has accrued, say, $200 in late fees, and that's a $2,000 a month rent, when the tenant makes that, if the tenant were to pay $2,000 to the landlord for the monthly rent, and the landlord can first off apply those late charges to that $2,000 payment. Therefore, the tenant has really only paid $1,800 of their monthly rent and are still late in paying the full rent, and can still accrue rental charges or late fee charges up to that 12%. So, a tenant may try to think they're being sneaky by just paying the rent and not paying whatever other fees that they have accrued. But they would still be in default of the agreement and could be accruing other charges. And paragraph 9 is about pets. So if the tenant has pets, they would need to negotiate a pet agreement with the landlord. And I'm going to talk about that in a lot of detail at the end, because we need to get into issues of emotional support animals and service animals and such, and how that relates to the lease agreement. So this simply says, this is even if there is going to be a pet agreement, this says if the tenant is in violation of any existing pet agreement or violates this paragraph 9, that the landlord can charge the tenant an additional rent for an initial amount, just like with the late fees, and then a daily rent for the pet until a pet agreement is executed between the parties or that the pet is removed from the property.
Allison, I just had a quick question. I have an owner who wants to have no pets, and they want it clearly spelled out with an agreement saying that they will have no pets. Is there a different form? Because I couldn't find anywhere.
There is none. The last, it says right here, paragraph 9, unless the parties agree otherwise in writing, the tenant may not permit, even temporarily, any pet on the property. So that is sufficient. The only way that a pet could be allowed on the property is if a pet agreement is executed. So you just need to point out to the landlord that the lease already deals with that right here. And again, we're going to be talking about emotional support and service animals, and they're not considered pets. So a landlord would have to allow those regardless of a pet agreement. And we'll go into that in much more detail at the end.
Allison, can you repeat what you said about the additional fee and deposit or something for pets?
Yes. So it says right here in 9B that if the tenant violates this paragraph 9 or any agreement to keep a pet on the property. So you're going to see when we go over the pet agreement is for a very specific pet. So even if there's a pet agreement and the tenant gets an additional pet, brings an additional pet to the property, they would be in violation of the pet agreement and paragraph 9. And in that case, the landlord can charge the tenant as additional rent, an initial amount of whatever that is, and a daily rate thereafter. So I usually make this amount equivalent to whatever I would charge as a pet deposit. So I might do this as $350 as an initial charge. And then, something like $25 a day thereafter, something that incentivizes the tenant to either negotiate a pet agreement with the landlord or to remove the pet if the landlord does not want to negotiate a pet agreement. Does that make sense now?
Yes. Okay. And then that's only if they're violating a pet agreement. Okay.
Yes. Now, when we get to the pet agreement, you'll see that the landlord can charge a deposit, a monthly rent. It can actually charge a refundable or non-refundable deposit and can charge a daily pet rate. But that is part of the pet agreement, which is a separate document.
And so, Allison, in the case where 0 pets, you don't put anything in B.
No, if you do not want to have pets, you want to have, this is what you would want to charge them if they bring a pet. If they are in violation of this paragraph, you charge them something. The landlord would charge them an initial fee and then a daily rate per day to incentivize them to remove the pet or negotiate a pet agreement with the landlord. And if the landlord does not want to negotiate a pet agreement, they don't have to. And in that case, the tenant would be charged a daily rate until they remove the pet. And you want that to be a daily rate that is enough that discourages or encourages them to remove the pet.
Okay, thank you.
So Allison, are there limits to the amount that you could put in there? So for example, could you put an initial amount of $1,000 and then $100 a day thereafter, something, pretty extreme so that they're going to feel that hurt? Is there a limit to that?
There's no legal limit. I mean, there's nothing in law that limits that amount. But I think, you also have to remember you could end up with a situation where a tenant immediately is not financially capable of paying that, and that probably would not be advantageous. And everything's negotiable. A tenant could say, I'm not going to sign an agreement that says $1,000 and then $100 a day. But, for most people, an initial $350 and then even $25 or $50 a day, that's going to be enough to really discourage them from doing it. But there is no legal amount or legal limit that I'm aware of. Okay, so security deposit. So this is where you would specify what the security deposit will be and how it needs to be paid. Typically, we see in our market that the security deposit is equal to 1 month's rent, but it is an absolutely arbitrary number because a tenant can do, say it's the rent is $2,000, and so you do the security deposit of $2,000. $2,000 can get eaten up really quickly if the tenant has done significant damage to the property. I have a story of I knew somebody who had a rental property, and they evicted a tenant, and before the tenant moved out, they poured concrete down the toilets. So that obviously was, whatever deposit that landlord had likely didn't cover that. Now, also, the security deposit isn't the total amount that the landlord can collect from a tenant in case of damage. We'll talk about that in a minute. I think I've just got that paragraph in here as well. I always recommend that a landlord require the security deposit to be paid by cashier's check, electronic payment, or money order. And the reason for that is you don't want to have receive that security deposit, have the tenant move in, and then have that check bounce, because then essentially the landlord has no security deposit. Landlords do not have to pay interest on that security deposit that they hold, even if they deposit it into an interest-bearing account. That's not the case in all parts of the country. And the landlord has 30 days after the tenant has moved out or has surrendered the property. The landlord has 30 days to either give an accounting of any part of the security deposit they're keeping, or to refund the security deposit. Often tenants think that they're going to get that security deposit the day after they move out, and that's not necessarily the case. And you'll see here is a notice, and you're going to see this throughout the document, where there are sections of the Texas Property Code that apply to rental lease or to lease properties.
Allison, I had it was Renee Livesey, who does a lot of lease listings, and one of the recommendations she made is to have the rent, but then the deposit a little bit different in money, so that you can keep the two of them straight. I thought that was a great suggestion, and thought I'd share that. So
yeah, and I've heard that too. And sometimes tenants think that the security deposit is last month's rent, and it's not. And that's something else, that having it be a different amount can sort of provide some clarification. So you can certainly do that. Again, the security deposit is completely arbitrary. In our market, we typically see it equal to 1 month's rent, or close to 1 month's rent. So it might be $50 more than 1 month's rent or something. So this is part of the security deposit paragraph. It lists all of the things that a landlord may deduct from the security deposit. So damages to the property that go beyond normal wear and tear. If the tenant didn't clean properly and the landlord has to have professional cleaning, if there's late charges that they've accrued and haven't paid, unpaid pet charges. So again, if they've violated that paragraph 9 and they've accrued pet charges, that can be taken from the security deposit. A number of different things. Any costs for reletting, if a tenant is in default and terminates early, any cost to restore walls or flooring, if the tenant has made alterations that were not approved in writing by the landlord. So a number of different things that the landlord can deduct from the security deposit. And I'll show you, there's a form that you can help your landlord by providing it to them to specify any of those charges. And here you'll see too, in the bottom paragraph 2 of the section, if the deductions exceed the security deposit, the tenant has the obligation to pay the landlord that excess amount within 10 days after making written demand. So again, the security deposit is not the maximum amount that the landlord can charge a tenant. It's just it's just risk mitigation for the landlord, so that they have some amount that they can keep if there are any of these deductions that are appropriate. And I often get calls from agents who are asking for their landlord client, what can a landlord deduct from the security deposit? And I would recommend going to this list and pointing this out to the landlord. And they need to be reasonable charges, of course, as it says at the top. So paragraph 12 starts talking about the use of the property and also, as I mentioned before, the occupants that are going to be residing in the property. So again, there could be persons that are occupying the property but are not parties to the lease. So in 12A, you want to list everybody that will be residing on the property, so their names and their ages. In 12C, it says that the tenant has to comply with any HOA rules or restrictive covenants. So it's very important that in the addenda paragraph that you check the box to indicating that the rules and regulations of the HOA are being provided, and then you provide those as an attachment. So the tenant cannot, be expected to follow rules and regulations if they're not aware of what those rules and regulations are. So it's really important to provide those. And then 12D specifies some uses that are not allowed on the property. So that includes having a spa or hot tub or a above ground pool or trampoline on the property. And those are all because of security issues or safety issues and insurability. And the trampoline one does come up. People may have their own trampoline for their kids and they cannot have the trampoline on the property. But it also talks about any activity which is a nuisance or noisy. They can't repair vehicles on the property. And really important, they cannot operate any business of any type, including a child care. And this does come up. And this doesn't mean that somebody can't home office on a rental property, but they can't really operate a business. So, where they would have customers coming and such. And they can't do anything that violates zoning ordinances, HOA rules, and they can't do anything that is illegal or unlawful or that obstructs or interferes with the rights of other people near the property. Paragraph 14 lays out access to the property by the landlord. So it says, of course, that they can advertise it for lease or for sale and put a sign on the property. That in paragraph 14B, it says that before accessing the property, that the landlord or anyone authorized by the landlord will try and contact the tenant to arrange for that access, but that the landlord has the right to enter the property at reasonable times without notice to make repairs or show the property, allow appraisers or insurance agents, things like that onto the property. And that the landlord also has the right, without first attempting to contact the tenant and without notice, to just enter the property or access the property to look at the property condition or to make emergency repairs, things like that. And then they can also charge a trip charge. So this trip charge is not a charge that the landlord is going to charge the tenant just for, having a repair person come to the property. It's if the landlord has made prior arrangements or their agent. So in the case of it was the property management company managing the rental property, if they've made arrangements with the tenant to access the property and then are denied or are not able to access the property because of the tenant's fault, that then they can charge a trip charge. And this is usually $75 or so. And the reason for this is because if a landlord has arranged for a service provider to come to the property and have made those arrangements with the tenant for the tenant to provide that access or allow the access, and then that service provider can't enter the property, they're going to charge the landlord a fee for their time going to the property. So it's really just to reimburse the landlord for those charges. Now, if the property is being listed again and the landlord wants to put a key box, like a super key box or a combination box on the property, this paragraph 14D is saying that the tenant agrees to allow that. And I'll show you, there is a form called the key box authorization form that you can use. It's not something that gets executed with the lease agreement. It's something that gets executed when the key box is being put on the property. Now, then it also says that the tenant here in D1 is that they're authorizing it for the landlord to do this during some period. So it could be at any time that they list the property, or you could say that it's, the last 45 days of the lease, or any renewal or extension. So I usually have this be the same number of days as notice is given, so that the landlord can then market the property with you and be able to provide access for other agents. But paragraph 14 continues and says that if the tenant withdraws this authorization, that they have to pay a fee to the landlord. So I would usually recommend that this be equal to 1 month's rent. And the reason for that is because you can assume that if the tenant is not going to allow access for showings once they've given notice, that it's going to be vacant for at least 1 month, because the landlord won't be able really to market it because no access is being provided until the tenant has surrendered the property. And again, here it says again that if anybody has contacted the tenant for access and the tenant denies it, that the trip charge can be levied against the tenant. Paragraph 15 is about the move-in condition. Just watching time. In paragraph 15A, if the tenant and the landlord have negotiated that there will be any repairs prior to the move-in, you would list that there. Otherwise, the landlord is not making any warranties as to the property's condition. The tenant really needs to have visited the property and determined that the move-in condition is satisfactory. And then 15B says that the tenant will complete an inventory and condition form, and I believe I have a copy of that at the end of the presentation. So this is a form where the tenant would specify what the condition is at move-in and that they need to provide it within a certain number of days. Usually somewhere between 3 and 5 days is sufficient. But I always remind the parties about this obligation, because typically both the tenant and the landlord forget about the tenant's responsibility to fill out the inventory and condition form. Paragraph 17 lays out the tenant's responsibilities for maintenance. They need to keep the property clean and sanitary. They need to dispose of garbage. And this is interesting. A lot of people aren't aware of. They need to, the lease agreement specifically says that they need to supply and change out heating and air conditioning filters at least once a month. I know a lot of landlords that actually go ahead and provide the air conditioning and furnace filters to make it even that much easier. But it's really an important thing, if you're representing the tenant, to make sure that they understand this responsibility, and for your landlords to point it out to their tenants as well, because tenants are not aware of these types of maintenance issues usually, and if can be really easy to destroy an HVAC system by not changing out filters and having them get so dirty that airflow isn't going to the equipment. Tenants also have to supply and replace all light bulbs, batteries for smoke alarms, and carbon monoxide detectors, things like that. Those things are not the responsibility of the landlord.
Alice, I have a question.
Yeah.
Is there a way to prove that a tenant has not fulfilled these responsibilities and has damaged the unit? I know that I've seen somewhere where they won't change the filter, for example, for months. And is there any way to prove that that has caused damage? And so
Yeah.
that
So usually an HVAC technician can tell you if it's the filter, a dirty filter that's caused the damage, because, you know, you can tell. And if they come there to fix the HVAC and the filter is dirty, then you know that they have not been changing it at least once a month, because it typically takes more than a month for a filter to get dirty. So it would be apparent by the condition of the filter and, you know, an assessment by a HVAC technician. So you want to remind tenants that, you know, that could be a many thousands of dollars, you know, obligation if they do not uphold that. What else? That they need to pay for extermination costs. That's not the obligation of the landlord. And they need to know the location. This is a big deal after we saw it last month with our storm, that tenants need to know the location and operation of the main cutoff valve and all electric breakers and how to switch those off to mitigate any potential damage. So, you know, if there is a pipe that bursts, they need to know how to turn off the water. And then up here, they also need to take necessary precautions to prevent broken water pipes due to freezing and other causes. But again, you know, these are things to point out to the tenant, but the landlord really should go over this in detail with their tenants, and they need to do a walkthrough and show the tenants where the water cutoff valve and the electric breakers are, so that the tenant is able to meet that obligation. Paragraph 17 continues with yard maintenance, and it describes what yard means and what maintaining the yard means. And in paragraph B3, it specifies that the tenant will water the yard at reasonable and appropriate times, including but not limited to the following times. So you might want to say, you know, once weekly or twice weekly, you know, during the summer, you know, or is allowable by city watering restrictions, because obviously there are city watering restrictions during, you know, drought periods. And then it also says who is going to be responsible for maintaining the yard. So it can be the landlord at the landlord's expense, and that the tenant will allow the landlord's contractors to have access to the yard. Typically, we see that it's the tenant at the tenant's expense, or it could be that the tenant will maintain a yard maintenance contract, and the landlord could specify with whom. So you're typically going to see the requiring the tenant to have a yard maintenance contract, or the landlord maintaining the yard if it's a really nicely landscaped yard. Because I will tell you, tenants do not maintain yards. They don't maintain them well. So if a landlord is really concerned about the yard being maintained and the landscaping being maintained well, then they should either pay for it or require the tenant to have a yard maintenance contract. Paragraph 17 continues with things that the tenant is prohibited from doing. They can't install fixtures like satellite dishes, things like that without the landlord's consent. They can't rekey any lock. So that's important. Now, landlords, I'll show you, there is a paragraph that specifies the landlord to rekey at the beginning of a lease, but the tenant cannot then rekey any lock or change any locks. They can't make holes in the woodwork or floors, except for a reasonable number, to hang pictures and sheetrock. They can't permit any water furniture on the property, which I'm not sure how many people still have water beds, but it's holdover from a time when those were popular. They can't replace, they can't paint or wallpaper, things like that, without permission from the landlord. and then this is one of the really very important paragraphs or sections of paragraph 17, and that is specifying whether smoking is allowed or not. I always recommend to the landlords that they not permit smoking. And it's very important for tenants to understand that it's the tenants, their guests, their family are not permitted to smoke on the property, including but not limited to the garage or outdoor areas. So that means that it's not just smoking is not permitted within the house, but it's anywhere on the property.
Allison, does this include vaping?
That's a good question. I'm not sure what the legal definition is of vaping. And I'm not aware of what potential damage there could be from vaping. I mean, this is really because smoke is not only damaging to finishes because of the odor getting into carpet and drapes and even the walls, but it's also a hazard. Somebody smoking in a house could fall asleep and burn down the house and things like that. So I don't know. That's interesting. I may see if we can get a legal opinion on that. I'm surprised that you are the first person who has ever asked me that, and now it occurs to me that's really odd considering how popular vaping has become. And then paragraph 18, interestingly, is all in bold because repairs are such a big issue in leases. And it's all about how quickly repairs have to be done, what types of repairs landlords are obligated to, and a lot of this is governed by the Texas Property Code. So it says, if the tenant is delinquent in rent at the time of the repair notice is given, then the landlord's not obligated to make a repair, and that repair of a heating and air conditioning system is not an emergency. Although a landlord, can't delay repairs that could cause the physical health or safety of a tenant, an ordinary tenant, to be at jeopardy. So, although heating and air conditioning systems are not an emergency, if you had somebody that whose health could be impacted by that, that could be a reason that a landlord would have to treat it as an emergency. But generally, a landlord can take 7 days to make a repair. And a landlord is not obligated to complete a repair on a day other than a business day unless it's required by property code. So again, unless it's required for somebody's health or safety, or to maintain the property as livable. But that means that if the AC goes out on a Saturday, landlord's not required to have somebody come out Saturday or Sunday to make that repair. They can wait until a weekday, and they can take up to 7 days to make a repair. So I had mentioned that I would talk about rekeying and such. Paragraph 19 is also governed by Texas Property Code, and it specifies the kind of security devices and locks that a landlord is obligated to provide on a property. So every single window needs to have a latch. There needs to be a keyed doorknob lock or deadbolt on each exterior door. There needs to be sliding pins on each sliding glass door, or sliding and a lock on the sliding door handle, or a security bar. So there's a couple of ways that they can provide that. And then there needs to be a keyless bolting device and a door viewer. So this is essentially a privacy lock. So it's a lock that is only operated from the interior. And then the landlord has to rekey security devices after the last occupant has vacated, or within 7 days after a tenant moves in. And that's a really important thing for landlords to remember. And that's really so that previous tenants don't continue to have access into the property and create a security and safety issue for the current tenants. I actually, think a really good way to deal with this is to put the keypad locks on exterior doors so that they can simply be reprogrammed, and the landlord and the tenant can, each be aware of what that keypad code is. So special provisions, like with a purchase contract, you want these to, really limit the kinds of things that you put into this. I had mentioned before that we recommend that you have the first full month's rent paid to JBGoodwin Realtors. So this is a good place to put that so that it's clear to the tenant that that's what they will be doing, is paying that first full month's rent to JBGoodwin Realtors in the form of a cashier's check or money order. You can put here that the tenant will obtain renter's insurance and that the tenant will have the property professionally cleaned after vacating and prior to the end of the lease term. Let's see, what time do we have? Do folks want to keep going, or do you want to take a quick break, or anybody have any questions?
We can keep going.
Okay. So if a tenant wants to terminate the lease agreement early, landlords do not have to allow termination except for in some specific situations that are set by statute. The first is if the tenant becomes a service member in the military or is a dependent of somebody in the military, that they can terminate the lease if they can provide documentation of their entrance into military service that is requiring them to move, if they have military orders for permanent change or deployment for not less than 90 days. So it's less than 90 days deployment, then they don't have the right to terminate, only if it's 90 days or more. And then that termination is effective the 30th day after the date on which the next rental payment is due. So that does give the landlord a little bit of leeway to, be able to find a new tenant. The other one is in cases of family violence. So this is if, a situation where there might be domestic violence in the, amongst the tenants, and there's a restraining order that is against one of the tenants. The tenant who is the victim has the right to terminate their obligations under the lease, not necessarily the one who is committing the violence. But again, then again, they have to give written notice, 30 days written notice of termination. And then the final one is in cases where a tenant is the victim of a sex offense or stalking, then they also have the right to terminate the lease, of course, because in the case of the family violence and then sex offenses or stalking, a tenant needs to be allowed to remain safe. So if none of those apply, then paragraph 28 continues with the assignment, subletting, or replacement, finding of replacement tenants. So it says that a tenant can't assign the lease or sublet the lease without the landlord's written permission. And the landlord is not required to allow for any of these. So they don't have to release a tenant from the lease except for in those 3 statutory situations. But if a landlord is allowing it, that the landlord, at the landlord's discretion, can allow for an assignee, a subtenant, or a replacement tenant. But at their discretion, that tenant can be required to meet the landlord's criteria. So the same criteria that the landlord would have specified, for any tenant, that they have to be able to meet, minimum income requirements, credit score, no felony convictions, no evictions, things like that. And if the landlord agrees to permit a replacement tenant or subtenant, that it specifies what the tenant will pay to the landlord, and recommend that it be equal to 100% of 1 month's rent, whether the tenant or the landlord procure that replacement tenant. And the reason for that is the landlord is going to probably come to you and ask you to either help market the property to find a replacement tenant, And even if it's the tenant that finds a replacement, that you'll need to be doing the screening of that replacement tenant to make sure that they meet the criteria. And it also says here at the bottom that, unless expressly stated otherwise, if it's an assignment or sublease, the tenant is not released from their obligations. So the tenant can, even if it's sublet, the tenant can still be obligated for, any of the terms in the contract. But we don't usually see assignment or sublet in this market. It's usually simply that lease is terminated and a new lease is signed with the replacement tenant.
And so, Allison, sorry. So how does that work, logistically then? So the tenant would be responsible for their last month's rent, and then they would pay an additional month rent on top.
Yes, it's a fee. It's not an additional month's rent. It's
Okay,
a fee. It's a fee equal to 1 month's rent, 100% of 1 month's rent. So it's not an additional rental payment. It's just because you will typically be charging your landlords 1 month, an amount, a commission equal to 100% of 1 month's rent. So this way the landlord isn't out that commission if they allow for a replacement tenant. That's why I would recommend it be 100% of 1 month's rent.
Thank you.
And then paragraph 31 is all the addenda. So the ones you're typically going to see here is the addendum regarding lead-based paint, and I'll show you that. The inventory and condition form, which I've mentioned, and I'll show you a copy of that. If there is a pet agreement that is being negotiated, or pets are going to be allowed, then you would have a pet agreement. And then if the landlord has any other rules that they want specified and they want to write up, you can attach those. And then the homeowners association rules, and I've already mentioned that. You might also see a pool or spa maintenance addendum if there is a pool or spa existing on the property. So those are the ones you typically see. Also, the residential lease guarantee, which I'll show you. And the residential lease guarantee comes into play if there is a guarantor. So if there is somebody else, say, a parent of the tenant who is going to agree to pay rent if the tenant does not pay the rent, you would have a residential lease guarantee, and I'll show you that as well. Paragraph 34 recommends that the tenant obtain liability insurance, and I like to specify in the special provisions that they will. And then paragraph 34I is very important. So this says that the landlord's broker, and you would fill this in JBGoodwin Realtors, and you will always check the box, will not act as the property manager for the landlord. We absolutely do not allow our agents to do property management for their landlord clients. It is a very, very high liability and low return business. And if you do provide property management services for your landlord client and you get sued, that is one case where the company will not represent you. So it can be very expensive. I've heard of an agent who was doing it on the side without the company's knowledge, and they got sued and it cost them $40,000. So just explain to your clients that you do not provide property management services for your clients. Now, if you own your own property, own rental property, of course, you can provide property management services for yourself. But you will never do it for your clients. But if a landlord is providing or is going to have a property management company, you would put the contact information there. Otherwise, you would check the box that the property will be managed by the landlord. And then that, to follow up with that, in the signature page of the lease agreement, you will not put your name there or sign, because you are not signing on behalf of the landlord under a written property management agreement or as power of attorney, because you will never have power of attorney for your clients. Again, too much liability. So the only signatories here would be the landlords and the tenants. And again, it's only the tenants are only the people who will be responsible for the terms of the contract. So it's not all the occupants. It's only the people that it's been agreed upon are going to be responsible for the obligations of the lease agreement. So here's the pet agreement. So it is a separate document. And as I said, it applies to very, very specific animals. So you need to put the type, the breed, the name, the color, the weight, gender, everything. So, you know, if this pet agreement gets executed and the tenant has, you know, a dog that's a golden retriever, and then, you know, that dog, you know, they get rid of that dog and they get, you know, a Great Dane, that pet agreement does not apply to the Great Dane. It only applies to the animal that is specified. So we need to talk about fair housing. And how it relates to assistance and emotional support animals, so service animals. So you need to tell your landlord that because they are working with a licensed real estate broker, that you are obligated, as are they, to meet the Fair Housing Act and the Americans with Disability Act. And because of that, then they have to follow the rules for service animals and emotional support animals. Now, service animals are animals that are trained to do a specific task for somebody with a disability, whereas emotional support animals provide comfort and help with the emotional well-being of people with certain types of emotional disabilities. So they're very different. And in each case, they are not considered pets. They are considered animals. That's different than a therapy animal. So a therapy animal is trained to provide comfort to a number of different individuals. So these might be people who go into nursing, or animals that are brought into nursing homes and things. So that is different. A landlord does not have to provide, allow a tenant to have their therapy animal live with them, only a service animal and emotional support animal. In addition to allowing the animal to live on the property, landlords cannot charge any pet deposit or pet rent because they are not pets, they are animals. And this comes up a lot. And they need to be certified or registered. And in the past, there have been a lot of sort of shady online services that you can pay $50 and they'll say, yes, you know, you need your emotional support animal. HUD is really cracking down on that. And I think that's a good thing, because I think it's unfair to the people who really do need emotional support animals to have people who are sort of abusing the system just so that, you know, they don't, there are no restrictions on their pet. So you can the landlord can require to see the certification. They can't ask somebody what their disability is, but they can ask for proof of that certification, and then follow up and make sure that it's certified by a valid service. There has to be an actual medical professional who has attested to the need for the person to have the animal for either emotional support or to perform specific tasks. So here's just a little bit more. Again, another thing is landlords can't limit the breeds as they normally do. You know, a lot of insurance doesn't or has restrictions. Now, if the landlord's insurance would get canceled, or it would be violation of their policy to allow a certain breed of animal, then they can actually deny that. But they would need to show that that's the case, and that, you know, no other insurance is available to them, you know, that at the same price.
Allison,
Mhm.
I was working with a client, and they have all the documents that the animal was a support animal, and the landlord asked for a photo, and because the animal was a pit bull, kind of made a fuss. And so then what they did is they said, well, the property is no longer available, we're taking it off the market. And
so So I would say from most courts, and I'm not an attorney, but I would say most courts would say that that landlord did that in order to not have to rent to that person. And that could be seen as a violation of Fair Housing Act. If you have that happen to a client, what I would recommend to them is that they go and find another property to lease, and you can provide them with the information of where they can file a claim of discrimination if they so choose to do that. But filing a claim is not going to get them into that house in the time that they need. So they do need to go and find something else to rent. But again, if a landlord's insurance won't cover a certain breed, HUD says that they can, and I'm trying to see, there's a lot here. And there is a document in the business operating system in the shared files that outlines a lot of this. And I'll show you, there is also a document that's helpful that Texas Realtors has. So these are, if you suspect discrimination, again, let your client know that there are places where they can file a complaint. So they can file a complaint with the Board of Realtors. They can contact the Texas Workforce Commission, which is, they're the ones that oversee the Texas Fair House Act, or they can call HUD and complain about violations to the Fair Housing Act.
Okay.
Yeah, but again, that's not going to get them into that house.
Right, right.
Yeah.
And I would think they wouldn't want to live there because the landlord's probably not going to be very favorable to them if they pushed it.
That's the case also. Again, that's discriminatory to treat somebody differently because of their disability. That would be a violation of the Fair Housing Act. But I think what you want to do is say, here are the places where you can file a complaint if you wish to do so. But filing a complaint is going to take time, and we need to get you into a home. So let's focus on that, and then you can decide what you want to do about the complaint.
Okay,
So,
thank you.
Sure. So there are a couple of documents that and I need to update this. It's not TAR anymore, it's TSR. But the first one is the general information for landlord regarding assistance animals. So this is a document that outlines the federal laws for the Fair Housing Act. And what I always do is I always attach this to my lease listing agreement so that the landlord can read through it and have some knowledge about the Fair Housing Act as it relates to assistance animals. Here's the thing about insurance policy. So in some cases, an insurance policy may contain restrictions on the types or breeds of animal that are allowed on a property. So HUD has said that if it would violate the landlord's insurance policy, and the carrier would either cancel the policy, increase the cost of the policy, or change the terms in an adverse way, that HUD will find that imposes an undue financial and administrative burden. So, however, if an investigator, in verifying that claim with the insurance company, would consider whether comparable insurance without restrictions is available in the market. So, again, a landlord could say, I'm not, going to deny because of insurance, but if a case were brought against them, HUD may find that there are other available, comparable insurance in the market, and they could then be seen as being in violation. So it's sort of fuzzy. What a landlord can do is ask for information about that pet, or excuse me, that animal. And that's the response to request for assistance animal. This is not an agreement because, as you can see, it's only signed by the landlord. So it's sent to the tenant, and it's acknowledging that the landlord prohibits pets on the property, and that because it's a service animal, that they are going to have to allow it. And then it can ask for a description of that assistance animal. And this is important so that a tenant doesn't, have an assistance animal and then, brings another animal onto the property or something that it doesn't meet that assistance animal requirement. And a landlord can also reasonably limit the the number of animals. So somebody can't, if somebody said, I have 10 assistance cats, emotional support cats, it's reasonable for a landlord to say, I'm not going to allow 10 cats. Yeah, so they can ask for information on the animal, and again, for that certification.
Hey, Allison.
Uh-huh.
I have a question about the insurance bit. Can we go back to that for a second?
Mhm.
So if can the landlord ask the client to cover that additional insurance? Let's say the insurance do go up because of the type of pet, the emotional support pet. And
You can't ask them to pay for, you can't have a deposit or any additional fees or anything if it's an emotional support or service animal.
Okay.
Yeah. Okay. Anything else about animals? This comes up
And
a lot.
Allison, just to be clear, you said the therapy animals, the landlord's not required to permit.
I'm sorry, what was that?
You said, did you say that for therapy animals, the landlord is not required to permit them on property?
Correct. So therapy animals are not, do not provide a service to an individual. They provide a service to various individuals. So if it's say a dog that's trained to go into nursing homes and make everybody at the nursing home feel better, that's different. That the landlord does not have to allow the tenant to have that animal, because that animal is not providing a service to the tenant. It's providing a service to other people. So it's an emotional support animal that provides a service to the tenant specifically by providing them comfort, or a service animal which actually performs a specific task for the individual. So, a seeing eye dog, or there are dogs that can sense when somebody's going to have an epileptic seizure, or there are even dogs that can sense diabetics insulin is low and they need to take insulin. So the landlord can't, sometimes it's not going to be obvious what that disability is. A landlord doesn't have to be told what the disability is, because the person has the right to keep that medical information private, but they can require certification, the certification form. Okay, the pool and spa addendum. So if there is a pool or spa existing on the property, this specifies who is going to take care of it, like the yard, whether it's going to be the landlord at the landlord's expense, the tenant at the tenant's expense, or the tenant's expense to hire to have a maintenance contract. Also says that here on B that the tenant will, keep any pool enclosures in operable condition and closed, that the tenant will prohibit children from using the pool without adult supervision, that they will let people under the influence of drugs or alcohol use the pool. They won't allow glass containers near the pool. So these are all things to limit liability. And then it also says here in D2 that the tenant will maintain a liability policy of their own in an amount not less than $300,000. So make sure that a tenant understands that, because that will be an added expense for them. And again, this is all about limiting liability for a landlord.
Allison, question.
Yeah.
So what if the pool is the community pool for the homes, the leased homes in that area there?
That's the responsibility of the HOA. The tenant wouldn't have individual liability for that.
Okay.
It's not their pool. It's not the pool on the landlord's property.
Got it.
It's a community pool. Just like an individual that lives in the community wouldn't be liable if a neighbor went to the community pool and was injured. The individual homeowners are not liable. It's the HOA. So then here we've got the addendum regarding lead-based paint, and it's very important that you use the one that is for leases. And you can see right there under the title, it says for use in the lease of residential property. And it is a bit different than the one that you use for a purchase contract. Primarily, Section B is pretty much the same as what, it would, although it would say seller, and you'd usually have it that check B in both instances if the landlord has no knowledge of lead-based paint and that they have no reports or records, because that's typically going to be the case. But here in C, it's a little bit different because it doesn't even give the option for the tenant to have testing done the way it provides the buyer the opportunity to test for lead-based paint. It simply says, if there are any reports or anything, that the tenant has received copies of that information, but normally that's not going to be the case because the landlord won't have any reports. So all you would typically do 99.9% of the time is check box 2 that the tenant has received the pamphlet, Protect Your Family from Lead in Your Home. And so you would want to provide that to the tenant. So you would attach that with this addendum. And this is only for properties that are built before 1978. We've got the residential lease guarantee. So again, if you're going to be in a situation where somebody else is going to be guaranteeing that the rent is paid, and if the tenant fails to make the payment, this is going to be a situation typically where you have younger tenants. So maybe folks that are in school or are in their late teens, early 20s, who have not been able to build up credit rating, or maybe don't have sufficient income, and a landlord wants to allow a guarantee. They're not required to allow a guarantee. This would be the person who would be obligating themselves to pay the rent, but also to pay late charges, return check charges, any repair costs, pet charges, anything that the landlord might have to charge to the tenant. This guarantor is responsible for making those payments if the tenant fails to do that. Now, a guarantor has to be screened just like the tenant does. And what you would be screening them for, though, is a higher selection criteria. So you would want them to be able to show that they make 5 to 6 times the monthly rent in income. And the reason for that is they have their own housing obligations, and you would want to make sure that if the tenant fails to make any of these payments, that the guarantor has sufficient income to be able to meet that obligation. And then the key box authorization by tenant. So again, this is not something that you use at the beginning when the lease is signed. This is something that you have that you use when the key box is going to be going on the property once a tenant has given notice and your landlord has come to you and asked you to list the property for them again and find a new tenant. And this isn't really an agreement. It's really more informational. So it's acknowledging that you're going to be, the broker listing the property, that a key box is going to be placed on the property as specified in the contract, that there's authorization for that. And then it's a good place to put some, like the showing instructions. So everybody is in agreement what the showing instructions will be. And the tenant has, knows when they might be having to allow for access. There's actually, and I cut it off, at the bottom of the page, it also advises the tenant to make sure that valuables are secured and that prescription medications are secured during showings, so that it gives them that notice. I had mentioned that there's a form that you can provide your landlord clients if they are going to be deducting from the security deposit, and it's the itemization of the security deposit. So this is where they can, it helps them figure out what things are deductible from the security deposit and what their values are. And then if there is any balance, so it starts out with the total amount of the security deposit, and then they deduct all of the expenses, and then if there's a balance after the deductions. And then it says here, and I know this is kind of small, but either encloses a check in the amount of whatever this balance is, which would be provided to the tenant, or if the deductions exceed the deposit, that the landlord is demanding payment of that excess as in accordance with paragraph 10 of the lease. So if you, when a landlord comes to you to relist the property, you can let them know, if you're going to be deducting anything from the security deposit, I can help you with a form to itemize that. And that is it. And what I didn't show you was I thought I had the inventory and condition form here. So the inventory and condition form, and let me stop sharing.
While you're doing that, Allison, can you answer one of the questions in the chat about the,
Yeah.
I had asked the question about if the committer of the violence was not a tenant, can you still early terminate? Or does the committer have to be a tenant?
Let me look and see exactly what the language says in that section. I believe, it says the tenant may terminate this lease if tenant provides landlord with a copy of documentation as described in property code, protecting tenant or an occupant from family violence committed by a co-tenant or occupant of the property. If the family violence is committed by someone other than a co-tenant or co-occupant of the property, the tenant must give written notice. So if it's a co-tenant or an occupant, the tenant, sounds like the tenant can terminate the lease immediately because they obviously have to be given the right to leave immediately. If or co-occupant, then the tenant has to give written notice of termination 30 days prior to the effective date of the notice. So it just depends on, if it's not a co-occupant, they have to give 30 days notice. Because yeah, you could see a situation where, you know, somebody says, I have to leave here because my abuser knows where I live and I can't have them coming to my house.
And that can't go against them either. When they move on to another place, that landlord can't claim that they broke the lease.
No, because they didn't, because it's statutorily they're allowed to do that.
Okay.
Let's see, I'm going to go through you. Ooh, are the tenants made aware that they were still owing? I'm not sure, Annette, your question, are the tenants made aware that they are still owing the rent in full?
Oh yeah, that was right after you spoke about the tenant paying the rent, thinking he's going to pull a fast one. He's paying it late, and then thinking that the rent will be seen as paid.
Yeah. I would assume
said that it wasn't, that he still owes the penalty, and is he made aware of that he is still in default or whatever of paying the rent?
There's nothing in the lease agreement that gives a time that the landlord has to make that notification. I mean, a landlord could wait until the end of the lease and just have that be, you have late fees, that are due. So there's nothing in the lease that says that gives them the obligation to do that unless they're deducting it from the security deposit, and then they have to itemize that.
Okay.
So somebody asked, what's the time frame that the tenants receive a copy of the executed lease agreement? If they're signing by DocuSign, they receive it immediately because they'll get emailed to them. If a landlord requests to use their own lease agreement, they can certainly do that, but you can't advise them on the legality of that because it's not a promulgated form. Dana, I'm going to mute you. I think you're okay. Is tenant required to show proof of renter's insurance? If it's being required by the landlord, then the landlord can require proof. Let's see. What liability do we have if we continue to work with a discriminatory landlord? Yes, a complaint could be filed against you as well. So you need to tell your landlords, if somebody wants to act in a discriminatory, if they want to discriminate against somebody that's a protected class, so any of the protected classes, and remember, there are federal protected classes, there are state protected classes, and then there are local municipal protected classes as well. If you continue to work with somebody who's denying people based on any of those protected classes, then yes, you are in violation as well. And if a landlord pushes it, you just have to tell them, I'm sorry, I can't work with you. It's, you know, my profession, I'm an ethical real estate agent, and my profession is too valuable to risk.
Allison, what is the requirement for when a denies an application? Aren't they supposed to give notice of why they're denying the application? And what is the ramification of them not doing that? Because I seem to run into several that they'll just say that they're denying it and not giving reasons.
Yeah. So tenants needs to be provided the selection criteria, the landlord selection criteria, before they apply, so they are aware of what the selection criteria is. Now, when you're working with tenants, you need to pay attention to what it says in the MLS. Does it say best qualified or first qualified? If it's first qualified, the agents are obligated to look at each application as it comes in and consider that application. And if they meet the minimum qualifications, then they should be approved. Best qualified, which is what you should put in MLS when you're representing a landlord, means that a landlord can, or an agent, you as agent, or the other, if it's a listing agent on the other side, that they can collect multiple applications, screen them all, and select the one that is best qualified. So there may be 2 or 3 that meet the minimum qualifications, but one has significantly higher income or significantly higher credit score. Then they can select that one. So the other ones might meet minimum qualifications, but weren't the best qualified. And if they're denied, then they should be provided a reason for the denial, and also information on, if it's because of their credit, then information on, if they don't agree with what the credit bureau says, information on how they can reach out to the credit bureau themselves.
Okay, so what do you do if they're not providing that to your clients?
Tell them that your client has the right to know why they're being denied.
Okay, we've done that. Okay.
Yeah. And if they're not doing it and it's really an issue, talk to the VP of your office and see if, it would be appropriate to file a complaint against that agent.
Okay. Well, it's multiple agents, it appears. So that's why I was like, okay. Really?
I think if you ask them, they're going to tell you why.
Well, a lot of times the agent will say they don't know, that the landlord hasn't really told them. They just said that they preferred this one, or, so the agents are acting as if they don't know what the reason is.
So ultimately the landlord makes a decision, but you can ask the agent. You could say, my client would like to know, in case there's something with their credit that they're not aware of. Can you please ask your client to tell, give the information on why my client was denied. And it may just be that they were not the best qualified. Now, if a client is denied for not meeting minimum qualifications and they were not aware of what the minimum qualifications were, they can demand their application feedback. So when you're representing landlords, you need to use our landlord selection criteria form to specify what the selection criteria is and upload that into the MLS. If you're representing the tenant, you should ask the listing agent, what is the minimum selection criteria? So that your client is not applying for properties that they will not meet the criteria for.
Right. And I've done that several times, but it appears that they'll just say like the best qualified, and I have to go back and say, okay, what is the minimum credit score that you're looking at?
Yeah.
Or what is, and they'll say, well, they're just looking at the overall picture instead of actually specifying specific criteria. So.
Okay.
There is a law that if you're denied based on your credit score, they are required by law to provide the reason for denying based on a credit score.
Yeah.
But my understanding is that it is the client who needs to request that information. I don't think it should be coming from us. And I would encourage, I would encourage the client to put it in writing that they are requesting that information.
Yes, and that's we're in the process of changing our screening systems, but the screening systems will generate that language for you if you notify them through the screening system that they've been denied. And yes, it provides them the information on how to contact the credit bureaus and their rights to contact the credit bureau, but it is not the obligation of the agent who is doing the screening to verify whether that credit score is accurate or not. That is up to the tenant applicant to deal with any errors in the credit scoring. And Terry, thank you for correcting me on guide dogs.
Okay, you said on the tenant screening. Now, if we have a tenant applying for a property not listed by JB, would we still go through the tenant screening for that?
No, the listing agent does the screening. That's why, but you wouldn't want to ask them what their selection criteria is so that you can advise your client on whether they meet the criteria. Now, totally other class of how to deal with if you're representing a tenant and they have issues that might mean that they don't meet the criteria, or if you're working with a landlord and you get somebody contacting you that says, I know my client doesn't meet the criteria, or you have a tenant coming to you. I mean, there are a lot of ways that you can deal with, you can sort of get around those challenges that some tenants may have. So landlord can, take a higher security deposit if somebody has poor, credit, or raise the rent, or ask for months of rent ahead of time, and those are things that tenants can offer a landlord if they have issues. You'd be surprised how many people have really bad credit and a lot of cash and are willing to, in order to get into a place, to say, you know what, I'll pay 6 months ahead. Sometimes apartment complexes can be more lenient than a private landlord, because a private landlord, I mean, for me, I currently own 2 rental properties. If one of my tenants defaults, that's a big deal. That's half of my, properties are default. An apartment complex that has, 300 units, if one tenant defaults, that's not as risky for them. So they may be more willing to take somebody with credit issues. But, if you have a tenant client who has issues that might mean they don't qualify, contact a listing agent and talk it through with them. And there are mitigating reasons why people have credit score issues and things like that. And, sometimes landlords, can be, empathetic to that. But don't ever hide it. Don't ever, don't hide anything from me, because it's going to come out in the application process. And we don't want you applying for things you can't get, because that can be really, they can rack up a lot of fees, and we don't want them to do that. Anything else?
Allison, what about, with the recent ice and power outages and COVID and all of this, we have a number of folks who've lost their jobs, at least temporarily, so that it could potentially affect their credit or their ability. But perhaps they're getting back on their feet now and they need a place to stay. How lenient is the criteria for those folks who were impacted by COVID?
That's entirely up to the landlord if they want to lease to somebody who has those issues or not. Again, I would recommend talking to the listing agent, or if somebody's bringing a tenant to you, talk to your landlord. But it's up to the landlord. The landlord can set the selection criteria and can waive it. There are eviction moratoriums in place right now. That doesn't mean that tenants are not obligated to pay rent. it just means that a landlord can't evict them for it right now. But once that's lifted, the landlord can, go after a tenant for the rent. And I think there was a lot, throughout the past year, of a lot of focus on tenants and providing relief to tenants. And there are forms of relief. There are, just because it's the pandemic doesn't mean somebody doesn't pay their rent. They have to, show that they are unable to because of the pandemic. It doesn't mean all evictions there's a moratorium on all evictions. It's moratorium on people who have lost their jobs because of the pandemic. So landlords can still evict for property damage, things like that, other violations of the lease. But there's been a lot of focus on the tenants, but I think everyone needs to also understand that landlords, majority of lease property are owned by individual landlords, not huge corporations that own, hundreds of properties or, our own apartment complexes. Majority of rental property is owned by individuals who own, three or, maybe one or two or three or four properties. If their tenants stop paying rent, the landlords still have that obligation to pay their mortgage. So, it can be difficult for the landlords as well as for the tenants. And most landlords don't want to just arbitrarily punish people and be insensitive to that. But, tenants are obliged to seek, assistance from, other sources, city resources and things for tenants. So it's a complicated issue, and we're not attorneys, so we don't give advice on eviction to our landlords. What you can do is you can guide them to where they can get the information. So, for instance, in Austin, the Austin Tenants Council, or there is a really great document that the Texas A&M's real estate program puts out. That's the Landlord Tenant Guide that provides really detailed information about how the Texas Property Code governs rental properties. So that's a document that you can download from Texas A&M, and you can give that to your landlords and tenant clients.
Allison, I also just put in the chat that TDHCA got $1 billion as in B dollars, and that is relief for not only tenants, but landlords too. So I would encourage you to see folks there too. They're behind, of course. It's a state agency. they're behind, but they are getting to all the applications.
Great.
I had a quick question. Just trying to find an apartment for somebody. Does anybody have any recommendations on a good apartment finder? Just type
Smart
it in.
Apartment Data. SmartApartmentData.com.
Thank you.
Is the best. It's $45 a month, but it's well worth it because apartment complexes are often paying 100% of 1 month's rent, sometimes more. So you'll get that monthly payment or that monthly charge back pretty quickly.
Yes, so you said Smart Apartment Data?
SmartApartmentData.com.
Yes, ma'am. Thank you.
Terry, you asked if we have a template for rental criteria. Yes, that is in the BOSS and the shared files. Listing of all protected classes. Yes, that may be something in the shared files. If you watch the Square One training I do for working with tenants, I have a chart in there that has the federal, state, and local for Austin protected classes. The inventory and condition form, it's a TXR. I don't know the number, but just search for inventory and condition form. So yeah, and again, Terry, thanks for that TDHCA. I may actually make sure people are aware of that in Westlake office and Lakeway or Lake Travis office when I do sales meeting next week.
Do you prepare CMAs for landlords?
Of course.
Okay, good.
Yep, they're the ones that set the monthly rent, so you need to advise them, and one of the ways of doing that is a CMA. Now, I really advise everyone to go back, download the lease agreement, and it's residential lease is what it's the title of it. and read through it, because, you know, again, it's a very, very complicated document. I didn't cover every single paragraph. But, you know, a lot of times agents come to me with a question about the lease. Either their tenant is asking what something, you know, about it, or landlords. And if you just sort of familiarize yourself with the document, you'll be able to find the answer yourself. So yeah, it's just like any of the other agreements that we deal with. It's good for you to be able to know where things are in the agreement and have a general understanding, so that you're not caught unawares when you're, you know, sitting down with somebody going over it, and they ask a specific question. You want to be able to answer it right there. And of course, though, if something isn't clear, always do reach out to management, and we're happy to help you get clarification.
And so, Allison, I just had a quick question. We're not using Rently anymore, I understand. So
correct. We're researching so they notified us that they were no longer providing, they're going to be phasing out the tenant screening system. And they're giving us some time to find an alternative. It's just with the storm last month and things, it's just taken a little bit longer than we anticipated, but the sales and leasing managers are researching other systems.
okay, so I have one that's going to be, I'm needing to get a lease for May 1. Who should I use then?
Use NTN. We have also had NTN, National Tenant Network, has been available, and there is a training document there on the business operating system. But you could also reach out to your sales and leasing manager if you need more training on that. Unfortunately, it does require the paper copy of the TXR application, and you have to enter the information. That's one of the reasons that we had added Rently, is because it's online. So you're going to have to collect the check and all of that, unfortunately.
Okay, so are they going to be looking for a vendor that doesn't require that in 2021?
Yes.
Okay, we should be able to come up with an online process.
Yes, absolutely. Okay. We're trying to find one that it will be entirely online. So payment online, application online, and that where they do the screening and have the option of them doing the rental verification and employment verification. Some agents like to do that themselves, and some don't. So we're trying to find one that meets as many of our criteria as possible, and is user friendly, and has good customer service, and it's a long list of wants.
Allison, I have a question. Now, a lot of agents are using the online criteria and the application and all of that. Now, for us as a tenant representative, how do we, besides just calling the agent, how do we find out what the criteria is when they don't actually list it in the listing? Is all within the system?
You have to call. A lot of the online systems will tell the applicant what the criteria is before they fill in the application, but otherwise you'd have to call the listing agent.
Okay, yeah, because sometimes you want to know if they need it before you actually take them to see the property.
Absolutely. Absolutely. Yeah, you don't want to show them a property they're not going to qualify for. And then they move in. Liz, I see your hand is up. Do you have a question? I guess not. Anything else? Okay. Well, thanks, you guys. And, you know, reach out to your sales and leasing manager in your office if you have questions. You know, if they're ever not available to you, you can certainly reach out to me as well.
Allison, this doesn't really have anything to do with the lease agreement so much, but I've been dealing with a lot of potential lease clients, and I'm concerned with some of them that they're scammers. How do you know for sure if someone's scamming? I sent somebody some listings, and I'm getting a weird vibe. So I looked up his phone number in Spokio, and he's not who he said he was.
So I always ask people to provide me with a driver's license.
Okay. I know somebody was really concerned about handing over their ID, and he was a legitimate person, but he didn't want to send anyone his ID.
So, ideally you would meet with even a tenant client in the office, and you would sort of screen them. You would ask them, what their income is, ask them all the questions you would need to determine if they meet criteria, and so that that information. And somebody's not going to come and meet you in the office if they're a scammer. They're not going to take that time. Obviously that we're not necessarily seeing people. Some people are choosing not to go into the office at all, even to meet with clients. In that case, do a virtual meeting with them, do a video meeting with them, and ask them to hold up their driver's license and just tell them, say, you know what, we haven't met in person. We don't know each other. I have some security measures that I take for my protection. And that's just how I do business. I do that when I have lease listings and the tenant reaches out to me, say from Zillow or rentals.com, and a tenant reaches out to me for me to show them a property. I won't show them the property unless I have a copy of their driver's license.
Okay.
And I provide that copy. I make sure that my husband has a copy of that driver's license so that he knows who I'm meeting with. And people, if you put it to people, you're like, we haven't met, and I just need to make sure that, that you are who you say you are for security reasons. Somebody who doesn't understand that is not somebody you probably want to be alone in a house with.
Okay. Yeah, I just noticed like most of the people I'm talking to have been talking to numerous agents. So, I was just wondering how most people go about this.
I wouldn't work with a tenant who's working with multiple agents.
Okay.
You're wasting your time.
Okay. That's good to know.
And you explain to them that that's how you work.
Okay.
Unless it's your lease listing. If it's your lease listing and a tenant wants to come see something, let them come see it. Show it to them if their agent's not available, because you want to get it leased. With tenants, as with buyers, don't work with somebody who's working with multiple people, because you're going to run all over town for them, and then somebody else is going to find them their rental property.
Uh-huh. Okay. Yeah, I was starting to expend a lot of energy on someone, and I'm like, I'm not.
That's why the buyer tenant agreement is good to do with tenants. It ties them to you. It lets them understand how you do business.
I think in this market, it's a little bit harder though, because every time they click on something that they like, they said they get tons of phone calls from agents. And then, so they're going to want to go the easiest path, which is not to sign an agreement with anyone.
No. The easiest path is to sign an agreement with you, and you'll find them properties. So that's not happening to them.
Yeah, that's what I
tried. You are going into the MLS. You are finding properties. You are calling those agents to find out the selection criteria and if there's any applications in hand and when it's available and all of that. So you're making those phone calls for them. You save them tons of time.
Yeah, that's my spiel. I just usually have been, and it's worked out pretty well so far. It's just a couple people I'm like, I don't know about these people because they just
cut them loose.
Okay.
Cut them loose.
Okay. All right. Thank you.
Allison, I did have a
lot of scam stuff happening.
There is
texts with scams and everything, and I'm like, how do you stay away from that? But I guess
you just use your intuition and screen people.
Okay.
Yep.
Thank you. Go ahead, Terry.
Yeah, sorry, Dana. I just had a quick question about any kind of encryption software. We are emailing IDs and pay stubs and everything else. And what encryption software should we be using?
We have a firewall. If you use your JBGoodwin email, it's the safest. I mean, I'm not a tech person. I don't know the terms and things, but we do have a firewall for our email service.
Okay.
So you can't verify that somebody isn't, hacking into their email, but ours is safe. That's why we require you to always operate all of your business communications through your JBGoodwin.com email address as opposed to another email address. It's yeah, I mean, JB is totally on top of that. And I should probably say Edward is on top of that.
Yeah, really. Thank you.
Yeah. Okay, well, thanks everyone. Have a great St. Patrick's Day. Drink some green beer.
Thank you.
Thanks so much, Allison.
Thank you. Hey, baby.
A mailbox belonging to Jenna Yellow. You cannot accept new messages at this time. Please try again later. Goodbye.